We will do a quick revision of Preamble chapter from Laxmikanth. So the idea of preamble was first used in American Constitution and we have borrowed it from there. It is based on objective resolution that was drafted and moved by Pandit Nehru. It has been amended only once, that is through 42nd Constitutional Amendment Act, and three new words, socialist, secular and integrity, was added. It was adopted and enacted on 26th November 1949. So here this adopted needs to be remembered. It was implemented on 26th January 1950. India is a sovereign, meaning it is solely responsible for its decision. No one has no authority over us. We are part of Commonwealth or UN by choice, and it does not hamper our sovereignty. Socialist, we have democratic socialism, meaning our aim is to eradicate poverty, bring equality, but we are not talking about state owned enterprises. Here both public and private sector can coexist. We follow mixed economy. In secularism also, we have a positive concept of secularism where all religion is equally respected, and we state has a principled distance from all religions, while in west there is complete separation of state and religion. We are a democracy and we follow indirect democracy, meaning we have parliamentary form of democracy where executive is responsible to legislature. This is the meaning of parliamentary democracy. Indirect democracy, tools like referendum, initiative, recall or plebiscite is used. Switzerland is an example of direct democracy. Republic, any democracy can be of two types, monarchy or republic. Monarchy where the head of the state is by birth, by virtue of being born in a royal family, and republic where the person is elected one. And there is absence of any special privilege for one single class. All office is open to everyone, the general public citizens. Then comes justice. It has been ensured through fundamental rights and directive principles. Fundamental rights mainly secures political justice, while directive principles talks about economic and social justice. Together, economic justice and social justice is called distributive justice. And this idea of justice was taken from Russian Revolution. Then comes liberty, where one is free to express themselves. One has the opportunity to develop their individual personalities. But and it is provided through fundamental rights, but it is not absolute, but qualified. There are restrictions put that Constitution has allowed state to have to put some uh, restrictions on the liberty of citizens. This idea of liberty, equality and fraternity was taken from French Revolution. Now comes equality, meaning there is absence of any special privilege. From Article 14 to 18 ensures equality. Apart from that, Article 325 and 326 ensures political equality. Article 325 talks about eligibility for inclusion in electoral roll. That is, no person can be declared ineligible on the basis of religion, race, caste or sex. And 326 guarantees adult suffrage. Then comes the idea of fraternity, meaning the sense of brotherhood. Constitution promotes this feeling of fraternity by system of single citizenship. While in countries like US, there are state citizenship as well. People belonging to that state have some special privileges, but that's not the case in India. Fundamental duties too talk about ensuring, promoting harmony among all. When we talk about fraternity in preamble, it has two connotations. First, dignity of individual should be ensured, and second, unity and integrity of the nation. Again, we have seen that integrity word was added later. There has been debate whether preamble is part of the constitution or not. First, in Beruberi case, Supreme Court although emphasized on the importance of preamble, but eventually said that it is not the part of constitution. But in Kesavananda case, it was declared that preamble is part of constitution, and again in LIC of India case, again it was reinforced that preamble is integral part of the constitution. This is another important fact, that preamble was enacted after the constitution, other part of constitutions were already enacted. Although preamble is part of the constitution, it is neither a source of power to legislature nor a prohibition upon their power. It is non-justiciable, that is, it is not enforceable in court of law. In Kesavananda case, it was declared that constitution preamble is amendable. Since it is part of the constitution, it can be amended, but the basic features cannot be done away with. So basic features cannot be disturbed, but it can be amended. Thank you.